A controversial bail reform law struck down days before it was going to be enacted. But the change to the Safety Act isn't statewide. CBS 2's Sabrina Franza spoke with an expert about what this all means come January 1st. Sabrina, it really depends on where you live.
Erica, this statute is long, it's confusing, and it's controversial. And in it, our experts say crimes fall into two categories: detainable and not detainable. With this latest lawsuit, now it's also a question of where the crimes and arrests happen, because come January 1st, some counties will follow the old set of rules and others will follow the Safety Act rules.
Let's start with a crime, say robbery, stolen mail. Pre-Safety Act, the process is simple: arrest, charge, see a judge. Judge sets bail or no bail. Post-Safety Act, the process changes.
And it seems to be that the legislature has lost their perspective with respect to the victims.
Our experts say the law deems some crimes non-detainable, like stealing those packages or other Class A, B, C misdemeanors. The person that gets caught gets a summons to appear before a judge later.
How is it that the state's attorney or the state's attorney's office can intercede on every single case that comes before a judge?
Unless the state files a petition, then the judge has to allow the person to be released.
Prosecutors have to prove that a defendant poses a risk to the safety of a specific person or persons, and/or as a high risk of fleeing before trial. They have to petition to keep that person in jail, which many say takes the power out of the hands of the presiding judge and puts the pressure on the victims.
For the serious violent offenses, there should be some consideration with respect to allowing those people to be back on the street.
Now intro this latest lawsuit. Kankakee County Chief Judge Thomas Cunnington ruled some parts of the Safety Act unconstitutional. It keeps things like having all law enforcement wear body-worn cameras by 2025, also mentioned in the act, but stops new bail reform in its tracks, so long as you live in one of the 65 counties mentioned in that suit. So if that package thief is arrested in Kankakee, they follow that old set of rules. In Cook, Lake, DuPage, and Kane counties, that's in our area, the Safety Act applies. Experts say expecting prosecutors to provide evidence you'd see at trial before the actual trial.
How can the prosecutor claim there's clear and convincing evidence when there's stuff that has to be analyzed?
All of this could change if that same judge issues an injunction before January 1st. That would mean the ruling applies statewide. The Safety Act would not go into effect in the new year and would likely instead go before the Illinois Supreme Court to review. We're in the newsroom. Sabrina Franza, CBS 2 News.
Sabrina, thank you.